My name is Ravi. I'm from Armchair Criminal and I welcome you all to this part of the program. This is the third part of a six-part series on confessions. At this juncture, I propose to ask myself the question, what does Section 78 of PACE say? What it says is, in any proceedings, the court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. That's quite a bit of a mouthful. First question arising out of that is we have to consider whether Section 78 imposes a mandatory obligation on the judge to exclude evidence in the trial. The short answer is that it doesn't. What it does gives the learned judge the discretion to exclude. Why do we say that? Is because when we consider Section 78, Section 78 refers to may. Therefore, it does not say it must. Consequently, there is a discretion that is given to the learned judge to exclude evidence where it is in all the circumstances, taking into account the circumstances in which it was obtained, and to admit the evidence would cause an adverse effect on the fairness of the proceedings. Therefore, it is important to bear in mind a few things when we consider this concept. That Section 78, first of all, ask yourself, why is it thought that Section 78 gives the court discretion? Because it says may, the court may. That's the first point. So it's a discretionary power. Secondly, the court will consider all the circumstances when the prosecution intends to adduce certain evidence, whether it should be allowed, taking into account all the circumstances, including the circumstances in which the evidence was obtained. So not only the evidence, but the way in which it was secured. Then, having considered that, the judge will consider, would there be an adverse effect on the fairness of the proceedings? Of course, we know that every single piece of evidence the prosecution would want to introduce as evidence will have an adverse effect on the defense case. But the question here is, would it be unfair to adduce it? So, the next question that we should ask ourselves is, what does the adverse effect on the fairness mean? I think I gave the clue. We have to consider, is it unfair in all the circumstances? Not only what is to be adduced, but the way in which it has been secured. Would it cause such a adverse effect on the proceedings that it is unfair to do so because it will affect the fairness of the proceeding. So there what you look to is, in essence, is there a real ground of making a submission based on that it would be unfair to do so. We need to consider the unfairness in taking into account a holistic view of the case. What you would find here is there will be competing interests. Section 76 will apply. Section 78, given the discretion, could apply. Right to a fair trial could apply. Right not to self-incriminate will apply. Right to a private life could apply. Public policy could apply. So there's a whole host of competing factors that needs to be accounted for. That is why when you look at how confessions are treated, how material that is being obtained as a result of confessions, it is difficult, almost impossible at times, to understand how the courts work, because there is so much of discretion and so many competing factors. Consequently, what I would suggest is that take a holistic view of the entire case. Look at the case by case. They are individual cases. No one case is the same as the other, which means two things. One, you got to know your brief inside out. Do a critical analysis of the consequences of the entire process. How the police got the confession, what did they do with it, what is happening at trial. Then, in the light of that, you have to identify the relevant authorities. There is no blanket rule that could necessarily be applied. That's the key. Why do I say that? Because the question that answers what I have said is this: if the court were to find the confession, or for that matter anything else, was obtained by unfair means, then would the court allow the confession to be admitted? Unlikely. Because section 76, 78 could apply, and Article 6 of Human Rights could apply. That is what we, at least I hope that is what I explained a few seconds ago. The next question to ask is, can the court be compelled to exclude the evidence based on the above argument? It will not take you by surprise when I say it all depends on what is to be excluded, circumstances in which the evidence was gathered, and other competing factors. Breaches of peace is another obvious point, because it comes part and parcel of section 76 and 78 and other rules. So let's consider what is the implication if police were to fail to properly record the interview, the confession. The first case that I would consider is an authority called Crown and Delaney. I have the authority here, and this is a case where the suspect was suffering from low IQ and education is subnormal, 17 years of age. Then he was accused of committing serious sexual assaults, and he was to be interviewed. When he was first interviewed, he denied the allegations. Then some 90 minutes or so later, he eventually began to confess. And the police basically downplayed the gravity of the offense and basically indicating that people would be sympathetic towards him because of his mental state and basically would try to help him. What is important there is you should be aware that there's a duty on the police to give a caution and to record everything contemporaneously, unless it would not be practicable to do. Here, the interview didn't fall into that category. And remember, this is a vulnerable person. Those confessions were to be relied on by the Crown. That was objected, and the learned judge accepted that there had been breach of the court, but held nonetheless that nothing was said or done in order to make the interview and the confession unreliable. Therefore, those confessions were admitted. He was convicted and appealed, and one could understand the learned judge's sympathy, wanting to that basically allow the boy as soon as possible to be freed from custody. And the Court of Appeal took a very different view. And what the Court of Appeal said was that there has been a breach of codes of practice, and the learned judge should have excluded the evidence, particularly when the appellant's age and his subnormal mentality and the behavior of the police that they had admittedly said to him, in other words, trying to basically say that people might be sympathetic towards him, said that therefore the Court of Appeal said the conviction could properly be described as unsafe and unsatisfactory. Therefore, the conviction was quashed. Next, on a similar point, I'm going to consider the case of Christopher and Wright. Here, the facts were quite simple. The police were basically acting as undercover officers in order to establish and secure stolen property from burglaries and thefts. So what they decided to do is to open a shop to buy goods. So it's open to the public. Cameras were set up, recording material was put in place. There were 2 police officers working there, and there was another group of officers who could observe what is happening in the shop from behind the screens or wherever in another room. There were people who were coming there offering all sorts of goodies and selling them off. The procedure was put in place to record things, and the police officers, as rogue, shady shopkeeper, had general conversation, and some people were coming more often than not, and general conversations took place. There came a point when the police officers decided to pull the rug, close the shop, arrest the whole lot of them. And people were tried, they were convicted. The 2 appellants argued that everything should be excluded under Section 78, because in essence what the police have done is a trick. They are acting as agent provocateurs, and it is unfair. Consequently invited the learned judge to exercise his discretionary power under Section 78 of PACE to exclude the evidence. Unfortunately, that didn't go down very well. They were convicted and they appealed. The Court of Appeal dismissed their appeal. What the Court of Appeal did say is this: Section 78 of PACE does not give a defense for use of agent provocateurs. Section 78 has nothing to do with that. In fact, the Court of Appeal said, yes, where evidence is unfairly or in a particular manner is secured, the court could take that factor into account. In other words, the circumstances in which the evidence was gathered. Here, the agent provocateurs, if that was they were. At any event, when one considers this authority, you will understand that they were not agent provocateurs. Secondly, there's a rule in Crown and Sang which says it doesn't matter how you gathered the evidence, so long as it is relevant, it is admissible. This is the paragraph from Crown and Sang the court applied. That although the scope of Code C of the codes of practice extended beyond persons in detention, it was intended to protect suspects who were or thought themselves to be vulnerable to abuse or pressure from police officers, and applied where a suspect was being questioned about an offense by a police officer, acting as such for the purpose of obtaining evidence. That since the appellants were not being questioned by police officers acting as such, and conversation was on equal terms. There could be no question of pressure or intimidation by the officers as persons actually or believed to be in authority, and that accordingly Code C did not apply in the circumstances, and the judge's approach could not be faulted. There you are. They were on equal terms, and they cannot be described as agent provocateurs. They didn't say, go and burgle a place and bring the stuff. All what they did is to open a shop. So therefore, it was available for the suspects to walk into that shop and sell if they wanted to. No pressure was used. And there were no police officers, as one could identify. So therefore, they were on equal terms. Like in Chandrasekhar, where the woman said, he's the one who slit my throat. And making the allegation. So the court rejected the argument that Section 78 ought to have been used. The next is a case that I would use to demonstrate the point is Crown and Bryce. This is a case involving an undercover police officer and the suspect. The facts were quite simple. An expensive Saab car was to be sold, and the police officer, undercover officer, contacted the person in order to purchase. They met. In the conversation, there was discussion, and in fact there was discussion as to how warm it is, meaning how hot, in other words, when was it stolen, and details, those kinds of things were discussed. Eventually the transaction took place, at which point the suspect was arrested. Again, I have the authority here that I'm looking at times. And he was interviewed. He made no comment in the interview. When the interview was terminated, had come to an end, he told the police officers, I can speak to you about the matter, provided it is not recorded. The police officer didn't give any caution, neither was it recorded, neither he was provided with the notes to examine and endorse it or reject it. He was charged. The matter proceeded to trial. And eventually, when he was convicted, he appealed. It was argued that his conversation after the interview was incriminating. Therefore, it should have been excluded, and what it tantamounts to is an interview. What the court did say is this: the tape-recorded interview had concluded, which I explained to you. What followed was therefore, at the very best, a break in question. In our judgment, that the submissions is unanswerable. The failure to caution the appellant again was not just a technical breach in the circumstances of this case. According to the police, Once the recorder was switched off, the appellant said he wanted nothing written down. He repeated that saying, "If you record it, I won't say anything." The officer's reply, "Well, what happened then?" That's the question. What happened then? And he said, "If you are going to record it, I don't want to cooperate with you." And the officer didn't deny that. He remained silent. Might reasonably have been taken as an acceptance of the appellant's terms. That's what I meant. The officer didn't say anything, so therefore, at least he acquiesced to the terms of the suspect that it won't be recorded. The appellant may well therefore have believed that what was not recorded could not be given in evidence. Consequently, he may have fallen into a trap. What is not recorded cannot be given in evidence. Hence the importance of fresh caution or reminder of it. Significantly, Mr. Nicholas, for the Crown, fairly pointed out the officer does not claim to have asked the question, "Is that everything, Paul?" until he was already sealing the tape. One might have expected that question to have been asked before the recorder was switched off. So you see, the police officers' failure to question again after the interview when the conversation was going on and to record things added to that the suspect's desire not to be recorded and the officer's failure to say anything to that made the confession unreliable. Because what it did is, in effect, though that question, what happens next question, went right to the heart of the issue of dishonesty. And it would have been wrong not to have excluded that, because it is so incriminating of himself. Equally, the police officer didn't have any notes that he had offered to the suspect to confirm or to dispute. In those circumstances, the court said that the evidence should have been excluded and allowed the appeal. Let's ask ourselves the question, if there had been lack of good faith on the part of the police, what would have been the situation? Remember, we looked at the case of Delaney, where the young boy with educational difficulties, how he was treated. And then we have the authority of Crown and Canal, which I will look at. Here, the allegation was one of conspiracy to rob. The suspect was interviewed no less than 4 occasions. The first 2 occasions, no caution, no recording. They secured material that they wanted, and then they held a normal interview under caution, covering the same ground that which was covered earlier. And the Crown understandably wanted to adduce that he was convicted and he appealed. The Court of Appeal held that one, following the guidelines set out in the codes of practice cannot be overemphasized. They are there for a reason. They are important to be followed. Two, that there's a requirement to record everything accurately as far as possible, unless, as we looked at, it is not practicable to do so. And that didn't appear to be the case here. Thirdly, the code of pace is there to protect the police too from allegations that they have been improperly obtained, i.e. the confession. The Court of Appeal held that in the instance case, if the trial judge had appreciated the gravity of the breach of the interview rules in codes of practice, the learned judge would have and should have acted under Section 78 of PACE to rule out the evidence of admissions from the case for the breaches which were flagrant, deliberate and cynical, and as the only effective evidence against the appellant was obtained in breach of the code. Therefore, the court felt that there was no option but to allow the appeal and quash the convictions. So you would note from there that if there is a breach of pace, you cannot necessarily cure that problem by having a second interview. What happens in the first interview could have a significant effect on any subsequent interviews. There's a caveat here, I think I could put. If the suspect had been given the notes, if there had been, then of course one would have thought that there would have been a record of the interview and would have been able to either agree or disagree with the contents. The Crown and Absalom is an authority that I will look at. But before that, let me consider the authority of Crown and Walsh. Again, this involved an allegation of robbery. The man was arrested and he was taken to a police station where he asked for a solicitor, which was refused. He was interviewed and no contemporaneous notes were made. Therefore, there was a failure to consider any material and to sign. He again asked for a solicitor, that was refused. The Court of Appeal on conviction found that the breaches were significant and substantial. I mentioned that for a reason. As I know of, we no longer consider the issue of significant and substantial issue. What we look at is Section 78. Because the Section 78 does not, in my understanding, anyway suggest it has to be significant and substantial. The case of Absalom. This is an authority that would be familiar to all of us. What is important to understand here is, whilst a series of questions would almost be obvious to all of us to say that is an interview. But where it is a single question, sometimes we might miss the trick. It is to prevent that and to highlight that issue. This authority is particularly pertinent. In essence, there was a public disorder. The defendant was arrested, taken to police station. At the police station, the custody sergeant knew the defendant to be on police bail for possession of drugs with intent to supply. He was asked to empty his pockets, which he did. Then the custody sergeant approached and said, "Put the drugs on the table," or words to that effect. What did he do? Just that. Produced quantity of drugs and put them on the table. He was subsequently interviewed and charged. But there was no formal record of the question and answers that the appellant was given to sign. Equally, it is important to note that this conversation took place prior to the suspect being told of his legal rights and entitlement. But remember, this was at the police station, in front of the custody sergeant. The Court of Appeal held that it was not impractical to have a formal interview, have a caution, recordings, everything, because you are at the police station. What else do you need more? And he was not given the opportunity to seek legal advice. In view of that, the Court of Appeal held that the learned judge should have excluded the evidence following the question that was put by the custody sergeant. Remember, the custody sergeant had specific knowledge about this man. Then the Court of Appeal went on to say this: the learned judge thirdly held that the caution given after the first question remedied any previous failures. There again, with respect, we find ourselves unable to follow the learned judge. It was, of course, quite proper to repeat the caution, but did not overcome the real gravamen of the appellant's complaint, which is the failure to tell him of his right to consult a solicitor and intonation of a course of very pertinent questioning at a time when he had not had the opportunity to obtain that advice, and at the time when his guilt, certainly of possessing, was apparent to the custody officer. I think that case highlights the importance of following the guidelines of the codes of practice, and that even a single question could amount to an interview, Equally, any subsequent interviews may not necessarily cure the problem. There is an authority which I very briefly will touch, called Samuel Colenius Joseph. Again, it's a robbery case where a solicitor was requested and that was refused. And again, the Court of Appeal was not particularly impressed with that situation. The case of Keith Sumrathwaite is an important authority. This basically confirms that Section 78 does not give the defense of entrapment in our jurisdiction, although that the court will consider the circumstances in which the evidence was gathered to decide. This, in fact, had two cases heard at the Court of Appeal simultaneously. The facts were quite simple. One case involved giving a contract to kill the defendant's wife. Second one, the wife giving a contract. This is the case of, remember, there are two appellants here. One is Keith Sumrathwaite, the second one is Susan Gill. In Susan Gill's case, she is giving the contract to kill her husband. Both were dealt by undercover officers, and instructions were given. Then they were both arrested, of course on separate occasions because they are separate cases, and they were tried. Needless to say, at trial the defense counsel wanted to exclude the conversations between the undercover officer and the defendant for each of these cases. Again, the Court of Appeal relied on the authority of Crown and Sang, saying it doesn't matter how the evidence comes, so long as it is relevant, it is admissible. And this is what the Court of Appeal said. I'll read a paragraph. In our judgment, Section 78 has not altered the substantive rule of law that entrapment or the use of an agent provocateur does not per se afford a defense in law to a criminal charge. A purely evidential provision in statute, which does not even mention entrapment or agent provocateur, cannot, in our view, have altered a substantive rule of law enunciated to recently by the House of Lords. Had the Parliament intended to alter the substantive law, it would have done so in clear terms. Here, the court also noted that these two undercover officers were not, in fact, agent provocateurs. Like with the case where we looked at the jewelers, the jewelry shop being operated by police officers for those who wish to come and sell stolen goods. Here they were not agent provocateurs. In fact, the Court of Appeal thought that the undercover officers were passive listeners to what these two defendants wanted them to do. Therefore, those appeals were dismissed. What I will look at is the authority of Attorney General, reference number 3. Looking at the gravity of the seriousness of the offense, and where we looked at, or at least we touched upon, the competing factors including public policy reasons and the overall duty of the court to ensure that the guilty are convicted and those who are not are acquitted. Acquit the innocent, convict the guilty. And how human rights also could play, as well as how other competing factors could come into play. The appellant was originally arrested in 1998, if I recall correctly, for an allegation of burglary. His DNA was taken. He was cleared of the offense. As the law stood then, there was a direction or authority in the code to say that the DNA should be destroyed. However, it was not done. Then, many months later, a 60-odd-year-old lady was burgled. Not only burgled, she was raped. DNA samples were taken, and the appellant's DNA was found on her, i.e., the DNA that was found on her matched the DNA that was found when he was arrested for the burglary offense, which should have been destroyed. He was interviewed and took another sample of DNA, so the second set. He was convicted despite the fact that the base code said that it should be, at least it should be destroyed, and it should have been destroyed. The matter went to the Court of Appeal because the Attorney General made a reference. Since the learned judge took the view at trial that there is a requirement under Pace Code that the DNA should have been destroyed, which was not done. I cannot allow that to go in. Therefore, I'm not allowing the DNA evidence to go in. Consequently, without which the prosecution could not run the case, they offered no evidence. The matter went to the Court of Appeal. The Court of Appeal gave their lordship's decision, but referred the case to the House of Lords. I have the authority here. It's a long authority, which is very understandable. And the question the Court of Appeal referred to the House of Lords on a point of law is this: where a sample of DNA is lawfully taken from an accused in respect of offence A, in this case the burglary, of which the offence the accused is subsequently acquitted, and information derived from the sample suggests that the accused is guilty of offence B, here the rape, Does the judge have a discretion to permit a prosecution to proceed against the accused for offence B? In other words, burglary DNA should have been destroyed, but that evidence suggests that he is guilty of or can be implicated in the second matter, which is the rape, or is the judge has a discretion to permit the prosecution proceed, notwithstanding the terms of Section 64(3)(b) of the Police and Criminal Evidence Act. So you have a conundrum here. Section 66 is the section which creates the which gives the Secretary of State basically the power to create codes for the peers, and it says it should be destroyed, or at least it said at the time. Then you have Section 78. Looking at all the circumstances, evidence can be excluded, may be excluded if it is unfair. So you have one problem, that two different authorities. Remember, if the evidence is relevant, it is admissible unless it comes within Section 78. Then you have a duty as the court to ensure that the defendant gets a fair trial. Article 6. Equally, ask yourself the question, how outrageous would it be if the court were to literally interpret and say it must be excluded, and he walks free? So you have a whole series of competing interests here. How do you settle it? The House of Lords took the view. Now, the human rights legislation, the European jurisprudence, do not prohibit the use of improperly obtained evidence. If I recall correctly, it is, I think it's some Swedish case, I think, that went to the Court of Ravi. At any event, there is no positive averment in Strasbourg jurisprudence, neither in our common law jurisdictions, be it in England, Canada, or Australia. Therefore, the House of Lords considered all these factors and equally took into account that human rights, even if there is such an obligation, that there are exceptions. You can do away with human rights rules generally if it is to stop a crime. 2, if it is in the national interest of security, or where the national economy is affected. What more do you want than a rape case? A 60-odd-year lady in her own house being raped. How can you justify that? No. The court said on page 22 of this judgment, in any proceedings, the court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard all the circumstances, including which circumstances in which the evidence was obtained, the admission of evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. Section 78. Okay. Then, the court, having considered all that, said this: the difficulty in this approach is obvious if one reads section 64 together with section 78. The statute is entirely workable without any implications. Moreover, the implication would result in a meaning which would be productive of absurd results which are contrary to public interest. In other words, you got to look at the public interest and refer to the Human Rights Act. If you correctly remember, I referred to an European authority where I said that in European jurisprudence, there is no such concept that if it is improperly obtained, it has to be excluded. The authority is Belgium and Switzerland. Then also the House of Lords relied on the case of Crown and Khan Sultan, which we will look at later, and dismissed, if I may humbly say, the whole argument from the appellant that the evidence should have been excluded. It would have been outrageous, would it not? Elderly woman getting raped in her own house, and the man is saying, no, it shouldn't be allowed. And the House of Lords dismissed the appeal. Finally, I'm going to consider the authority of Khan Sultan. This is a House of Lords case, and very similar situation to the one that we looked at. There's public policy involved. Here the allegation was importation of large scale of drugs into the country. The police bugged a house where there were discussions taking place, including Mr. Khan being there and taking part. Yes, in order to do that, they had to do it discreetly and secretly, needless to say, and there was some minor damage to the property. Conversation was recorded. That was adduced in evidence. The man was convicted. He appealed. His appeal, needless to say, was based on that discussion should have been excluded, and that it was the relevant evidence was obtained illegally, and it would be wrong to have admitted. The Court of Appeal dismissed the appeal. A minor criminal damage to a house, could that be compared to the importance of detecting a serious crime as this? Okay? It was secretly done. So what? Compare and contrast. What is at stake here? It is wrong for one to expect that under those circumstances the evidence to be excluded. This is what the Court of Appeal said in applying the rule in Crown and Sang, that in circumstances including the facts that the trespass and damage were slight and the criminal conduct being investigated was of great gravity, albeit the evidence constituted a breach of Article 8, right to private life, of the European Convention for Protecting Human Rights and Fundamental Freedoms. The invasion of privacy with the attendant trespass and damage was outweighed by the public interest in the detection of crime and could not be regarded as having such an adverse effect on the fairness of the proceedings that the judge ought to have excluded the evidence of the conversation in the exercise of his discretion under Section 78 of base. The court accepted, yes, there is a slight breach of human rights, right to private life, bit of criminal damage. As I said earlier, so what? You compare and contrast. What is at stake here? You've got a man who's dealing with large scale of drug importation as opposed to a little piece of damage to a property. And, his right to private life, he says, was interfered with. I'm not sure, when one really considers, is committing an offense of as grave as that importing drugs constitute part and parcel of one's right to a private life. I don't think so. That is all I intend to say at this stage. This will be expanded further in part 4 and onwards. I hope this has been useful and that you enjoyed. I look forward to seeing you all again soon. Thank you for your valuable time, and God bless.